Jai Bhim, dear friends. Welcome to another episode on the AM YouTube channel. Today we will be walking you through the nuances of the UCG Equity Regulation 2026, which has created a big furore in the country uh, on the basis of either discriminate the communities which are being discriminated, as well as those who feel that the discriminating communities also feel that this bill is not doing justice to them. So there is a lot to know into the insights of this bill. And today we are, as our special guest to walk us through these details, none other than Professor Sukhdeo Thorat, who himself has been at the forefront of this entire journey. As an ex-UGC chairman, he has been involved in this journey at a very intimate level. Also, as a civil society leader and an activist, he has been continuously engaged in the social welfare programs. So I don't see any other person who is more equipped to walk us through and give us all the details about this particular issue. So with that, let me welcome Professor Sukhdeo Thorat to our discussion today. Jai Bhim, Professor Thorat.
Jai Bhim, Jai Bhim. Jai
Thank
Bhim
you
to
so
all.
much. Thank you so much for sparing your valuable time.
It's a
And
pleasure. Pleasure. Yeah.
yes, so today we would like to hear from you about the background of where we are today. I mean, today in the UCG Equity Regulation 2026, it has created a big furore across the country. And before that, I know it has a background before it reached this step, and also there is a lot of anticipation going forward. So, if you could walk us through that part, and then we can analyze about what this particular bill and its nuances are. And after that, I would also suggest that we do a comparative analysis in a limited way between how discrimination is handled in India at the legal level, at the policy level, and how it is handled in the United States at the policy and legal level. So that way we can get some perspective at the global level. So over to you, Thorat, sir.
Well, Jai Bhim to all of you. And I'm so happy that Ambedkar International Mission has uh, organized this discussion on the uh, University Grant Commission Promotion of Equity Bill uh, 2026, which has led to a lot of controversy and agitation on the street. And in response to that, the Supreme Court has kept the bill temporarily in abeyance, and while the 2012 regulation will continue, and the first hearing will be conducted on 19 March. Now, I think let me give the background of the bill as such, so that you have a reasonably good idea as to what is the present situation. This is not a new bill. 2026 promotion of equity in higher education is not a new bill. It is a revised version of the 2012 bill. And 2012 bill was uh, brought by UPA 2 government, that is the Congress government in 2011, uh, at the end of the 11 or beginning of the 12. Uh, and therefore, why 2000 bill was brought and why 2026 bill was revised, there is a background to it, and which I'll very briefly mention to you. 2012 bill's background is this, that uh, when I was the chairman of the UGC during 2006 and 2011, during that time and earlier also, there were lot many cases of discrimination reported in the newspaper, and significant number of cases of suicide by the scheduled caste and scheduled tribe student. Uh, this In this background, there were two suicides in All India Institute of Medical Science, Delhi, and there was a lot of agitation by the Dalit student in that institute. So the principal secretary of the Ministry of Health and Family Welfare came to approach me with a suggestion that they would like to constitute a committee and I should chair that committee. And this committee should um, study the reason behind the suicide in All India Institute of Medical Sciences. Um, I did a survey based on questionnaire and interaction with the uh, say scheduled caste, scheduled tribe students, which were about 50 of them, and came with a report. And the report really, for the first time, brought out in numerical term and somewhat systematic way the forms and nature of discrimination being faced by the scheduled caste and scheduled type student. It emerged that the student faced discrimination both from the teacher as well as from the student. Uh, there are sphere where they face discrimination. They face discrimination in the classroom. Uh, they face discrimination in the science, in the laboratories, that they don't get the laboratories as early as the other student will get, and the attention that the teacher should pay to them while experimenting. Also, the evaluation and examination. Evaluation and examination was the area which was really reported uh, the sphere of discrimination. And of course, then the outside the classroom and outside the teaching arena, the student reported discrimination in the hostel, where scheduled caste student will face discrimination if the scheduled caste student are located in a wing where majority of the students are from the high caste. Their rooms were bolted from outside. Some feel the slogan were written on their door, so they face discrimination. So scheduled caste student, whenever they get an opportunity to transfer the room, change the room, they will go to the wing where a majority of the students are Dalit. Also, there is a discrimination in dining hall. They would eat separately, generally speaking. There is a provision of a private mess. So those organizations, the private mess was based on the caste. Also in the social function uh, and sport. So these are some of the forms of discrimination that came, which affect the students psychologically badly, and one or two isolated cases when the students are really pushed to the wall and they are not able to handle it psychologically, some of the weak student mentally, that result into the discrimination, suicide. As a response to that, the institute has taken some measure. But after 6 months or after a year or so, another suicide happens in one in JNU, another in I think IIT Delhi and elsewhere. Uh, so I was sort of pursuing the education minister and to sort of have some regulation. By that time, my term was over, but I had requested him to uh, have some provision, safeguard, legal safeguard against discrimination. Then the Kapil Sibal, who is a law minister, a law person from law at that time, became the education minister, and he took a lead. And then I was asked to prepare the list of the discrimination that generally the scheduled caste student face, and then they will put the legal provision into it. That's how the 2012 regulation was brought in 2012. Now, this 2012 regulation has the goal is uh, to promote equity and social inclusion and harmony on the campuses in the university and the colleges. Um, and that it has generally two provision. They deal with these two provision. First is to, whenever the incidents happen, the student can make a complaint to the university. A administrative office was recommended in the regulation. What is called equal opportunity office and equal opportunity anti-discriminatory officers. That was the administrative setup. So whenever the scheduled caste or any student sort of face discrimination, the equity officer will anti-discrimination officer will consider it, recommend it to head of the department. That's the administrative provision. It also lists about 20 forms of discrimination specifically observed in the education institution. Uh, and then the second strategy is to sensitize the student about not to observe the discrimination and in other form, generally respect everybody and have equal behavior. Uh, so that second strategy was also uh, is a part of that regulation, and that regulation remain in practice then. But despite of that regulation, the Vemula suicide case became very, very popular and serious case. It was followed by another suicide by Payal Tagdi, a scheduled tribe medical student, MBBS student, who has completed MBBS as a matter of fact. Then again, it was followed by Solanki in um, uh, Indian Institute of Technology, Mumbai, and as a result, I think the formation of regulation was sort of in the process, but then Kapil Sibal took a lead, and I was asked to list the discrimination, and they would put the other legal provision. So that is how the act was brought in. But after these three suicide, the two mother, Vemula's mother and Payal Tagdi's mother, went to the Supreme Court. That despite this regulation, suicides are happening, which means that regulation are not being enforced honestly. Disha Wadekar, who is a lawyer in the Supreme Court, was a petitioner, and the one of the senior lawyer um, was a petitioner. Uh, and the Supreme Court then summoned the UGC and asked them that please report the status of the implementation of this regulation. The UGC said that yes, they will follow it. So UGC, in response to that advice, written a letter to the various colleges and university and asked them as to how many of them have set up this equal opportunity cell and whether they have received complaints, and if they have received, how have they dealt with. And the Supreme Court, the UGC reported to the Supreme Court that about half of the universities had set up the equal opportunity cell, but the cases reported were very, very minimum, and those students were then sent to counseling. They were not really considered in a serious way. Uh, the Disha Wadekar, as a petitioner, has suggested some improvement in the 2012 regulation. As a result of that, the Supreme Court suggested to the UGC that they should make some improvement, and then UGC said that yes, we are coming with a revised and improved regulation, and that is how 2026 regulation with some improvement was uh, passed by the UGC and gazetted in January 2006, and it was also placed on their website. Now, in a response to that, the general student then agitated and opposed to this uh, this regulation. This is the background, Milind, about the current situation.
Thorat sir, thank you so much for the detailed rundown. This clearly makes this whole current affair, brings it in context to what has happened in the past. So, as we understand, the 2026 equity regulation are supposed to be an extension or rather improvement over the 2012 regulations by UGC, and that too on the guidance or on the mandate of the Supreme Court. So now that we look at the 2026 regulation and it has been socialized, how do we look at it? Is it really an improvement? Does it fill the gaps, or does it fill the lacunas that are there in 2012, or does it deviate from the original thing itself? And so if you can just throw some light on that part.
In my view, it watered down the 2012 regulation. 2012 regulations, in large extent, are better than 2006. There are serious limitations with this regulation. Although in some area they have made improvement because these suggestions were made by Disha Wadekar. Those two improvement also I will suggest. I think the limitation of this Act 2026 regulation is that one, which that this limitation was also there in 2012, but it was not ratified into 2012 regulation. That is, this regulation applies to all higher education institution in the country. That is what the regulation says. But when they come to the definition of the education institution, they say that the university and the colleges under the Section 3 of the University Grant Commission will be included. Now, under Section 3 of the universities, UGC is only the university and the colleges, about 1,100 universities and about 43,000 colleges from the different states. Now we have education institutions like IITs and IIM and standalone institutions, which are not set up under the or recognized under the Section 3. The IITs are under the IIT Act of 2061. They are called National Institution of National Importance and enacted by the Parliament. Similarly, the management also under the Management Act of 2017 is applied in retrospectively. Standalone institutions are those who provide, teacher training degree or nursing training, uh, and they are, and some of them are management also. They are under the All India Council of Technical Education. So it seems to me, this is my feeling, is that these all are outside. They are not really, strictly speaking, don't apply this law. And there is a confusion at least. UGC may take a position, but there is a confusion. I remember that when Solanki's suicide happened in IIT Bombay, and I was invited to give a lecture, and I went there. And prior to that, I had a meeting with the director of the IITs, and I asked him whether you are applying using this regulation, and they were not aware. They were ignorant. The IIT Delhi director, when I went, there was also a suicide where I went and gave a lecture. I meet a director, and he took a much more stronger position that it doesn't apply to us. So, so you can see that. But there are other also institutions, agriculture university, agriculture colleges. They come partly under UGC, but they are really under Indian Council of Agriculture Research. Then there are medical university, medical colleges. They are under Indian Council of Medical Science. Then there are law university, law colleges, which are under Bar Council.
Right.
And there are, the pharmacology, Unani, and dental council. So I think there has to be a clarity in the regulation about the institution to be covered. My suggestion I have made is that this regulation should not be brought by UGC or even should not be brought by the Ministry of Education. They should be brought by the Government of India.
Very true.
Because there are educational institutions under many ministries. Even defense, National Defense Council of Pune is under the Ministry of Defense, and there are some other under home.
Right.
So it is the Government of India regulation, then apply to all the education institutions coming under the various ministries. Milind, the most serious limitation of this act is that both the Act 2012 and 2026 improved, they define what is discrimination. And that definition of discrimination is based on the United Nations discrimination, the discriminatory, differential treatment, and others. But there is one more thing, that is that in addition to that, they also say that discrimination associated with caste of the scheduled caste, scheduled tribe, and OBC. In addition to the general provision. In general provision, caste is also included. But the 2012 regulation lists the forms of the discrimination.
Right.
There are 28 forms of discrimination in the 2012 regulation. The forms means, which type of behavior of the high caste or anybody will constitute discrimination. And so that scheduled caste student can make a complaint if you find that there is a discrimination in the sphere which are mentioned in the regulation. Now, 2026 Act completely removed that, and it leave it to the Equity Committee. In 2026 regulation, there is a provision of Equity Committee, of which Vice Chancellor is the chairman, and there are 10 members, and they consider the complaint and all that. So they will make the list of the type of discrimination.
Right.
So this is very strange, because identifying a discriminatory behavior is a very tricky and difficult job. committee consists of vice chancellor, two, three professors, senior professor, member from the civil society organization, some student. They don't have capability to specify the forms of discrimination. Uh, the Anti-Discrimination Act of 1955 lists about 1780 forms of discrimination. Atrocity Act initially, I think, had about 20 to 20 forms. Now, over a period of time, they discovered that there are other spheres where discrimination takes place. So they have expanded it in the amended act in 2015, and the sphere, the sphere now, the type of forms of discrimination are run into about 40. So this is the problem. And if you leave it to each of the institution will list it, it is quite likely that some other institute will have another list where there may not be some form which are identified the other institution. This will create a difficult situation legally. So that is one of the limitation. There are other two limitation. Is that the equity committee is chaired by the vice chancellor. Now, generally, the inquiry committee, which look into the complaint, is not chaired by the vice chancellor. They make the recommendation to the head of the institution, which is vice chancellor. The vice chancellor can't sit on the take both the decision, make a recommendation as well as finally approve it. So somebody else should be the this thing. So these are some of the limitation of this act. The some they have accepted, with made by Disha Wadekar, that if there is a complaint against the head of the institution, what do you do?
Yeah.
So there should be somebody from the outside. So they have created an ombudsman authority where the student can make a complaint. So the other part of this 2026, which is better, is that they have several ways and means of uh, whereby they sensitize the student to not to practice the discrimination. Like a ragging act, when the student sort of registered, at that time he or she has to give an undertaking that they will not practice discrimination. They have also recommended something like a equity squad, a, a, a person in the department who will also look after that the discrimination is not practiced. So that kind of mechanism, workshop, posterization, these are some of these. There is a limitation to that which I have pointed out, but that I will take later on. We will discuss the American theme. So this is the nature of this limitation of the 2060. Otherwise, they are same in this respect, that their goal is to promote equity and social inclusion. That there is a provision of action if there is a discrimination, and that there are measures for sensitization. That there is an administrative mechanism of equity committee. There is a equity officers also, anti-discrimination officer. uh, uh, and there are several ways whereby they will propagate this, the sensitize them not to practice discrimination. So this is broadly the contours of this act, the regulation.
Okay, again, that is very insightful. So, on the surface, things might look good and acceptable, but the nuance, the devil is in the details. So, in this case, like what it covers itself is not, there is no clarity, it can be ambiguous, or the
Yeah.
interpretation of discrimination also is left to subject to interpretation by those authorities individually. So, that can be abused, or there can be bias that can go through it. Now, we know that there are these limitations to this 2026 regulation, but we also see a lot of backlash coming from the open category students, and they seem to raise a lot of concern about this, that they will be the ones who will be victimized and they don't have any safeguards in this. So if you can throw some light on that part.
Yes, I think there has been a agitation of a very unusual nature, and they have made certain complaints. And on the behalf of the agitator, three Supreme Court lawyer, in fact, one of the person is the president or general secretary of the Bar Council, a lawyers association, and there are two other. They have been to the court. Their complaint, formal complaint, which have been mentioned in the petitions, are two, three. The main complaint is this. What they are saying is that you have a general definition of discrimination, under which the discrimination is mentioned. Now, we must remember that 2006 regulation and even to a certain extent 2012 regulation doesn't only deal with the caste discrimination. It deal with the discrimination associated with race, color, religion, uh, then ethnicity, that is tribal or non-tribal, physically handicapped, and also economically weaker section. So caste is one of them. So there is a general provision of discrimination against this multiple form. But beside that, there is, as I said, there is a additional provision for caste-based discrimination, because that was there in the 2012 regulation, and caste discrimination is a very prominent discrimination. It is to this that they have opposed. They say that if the caste is also included in the general definition of discrimination, why do you need a special provision for caste discrimination against scheduled caste, scheduled tribe, and other backward castes? They have also objected to other backward castes because in 2000 regulation there was no other backward caste. In 2000 regulation was the caste discrimination based on scheduled caste and scheduled tribe, or scheduled caste and scheduled tribe. Now in 2006 they have 2026 they have added OBC. Now, their objection is that why you are having a additional provision of caste discrimination for scheduled caste, scheduled tribe, and OBC if the caste is also already covered in a general discrimination. That is the one complaint that they have made. Now, as a follow-up of that provision, they are saying that we will be subject to discrimination. People might file the complaint against us. Then they are additionally saying there will be what is called reverse discrimination, and it will bring a divide on the campus. This is the main argument, that caste discrimination should not be mentioned separately. It should be made a part of the general definition. That their demand is that if the caste discrimination is maintained, then in that case, high caste should also be included. Discrimination of high caste. And that if the caste clause is maintained, then there will be a reverse discrimination of the high caste student, and that there will be divide, and there may be a chances of probability of false cases. So these are the major criticism by these people, to which the Supreme Court has not given a decision, but orally they have lent a support to it, which is very disturbing. They also say that there might be a divide in the society. Why caste should be mentioned separately? Why there one of the demand is that why ragging is not brought into this regulation. So these are the criticism that they have mentioned, and therefore Supreme Court has kept this regulation in abeyance, and allowed the 2012 regulation to continue, and they will set up a separate committee because they feel Supreme Court argument is that this is vague and it has a chance of misuse. So they will set up the committee of judges, and possibly revise this 2026 regulation. Now I will mention my opinion on
Sure.
this criticism that they have made. In my view, I think this point raised by the general student are not sustainable point, and they are not based on the proper theoretical and empirical evidence. The my suggestion is that I think the caste and untouchability with discrimination is a very unique form of discrimination. Uh, the Supreme Court, when Atrocity Act was enacted, it justified by mentioning that the crime under the Atrocity Acts are of a very unique and special nature, and they are to a greater extent different than that of the crime under the Indian Penal Code. So, that being the case, there is a justification that the caste discrimination of scheduled caste, scheduled tribe, and OBC should be mentioned separately and also included in the general provision. There is no harm.
Yeah.
The OBC is included simply because the reason is that till 2008 and 2009, there was no reservation for OBC in central education institution for the faculty and the student. Now, 2008 and 2009 discrimination, the reservation was made, and as a result, they also began to feel the discriminatory behavior from the high caste in the educational institution. So that's one of the reasons why OBC is brought into this, and OBC face discrimination, and the Article 16 of the Constitution justified that. So this is one point that I want to make. Second point I want to make that even if we include the caste in the general provision, the discrimination associated with caste and untouchability, religion, race, color, physically handicapped differ. There is a similarity insofar as they face all face discrimination of some sort, but the nature of discrimination and source of discrimination are different, and therefore the forms of discrimination will also vary. Therefore, for each of these, you should have a list of discrimination, and you have to define it. Although all are discriminated, that point has not been considered by the Supreme Court. That's my argument.
Right.
For example, there is a difference between the Shudra, OBC, and the scheduled caste. The OBC faced discrimination traditionally. They were denied right to education. They were denied right to property and all that. But later on, they were given the right to land. But they faced discrimination in terms of denial of right. The scheduled caste not only are denied right to education and property, but they suffered from the idea of purity and pollution. They are considered to be polluted people, therefore not to be touched, therefore untouchable. Not to be approached, very come close, therefore unapproachability. Not to be even seen eye to eye, so therefore unseeability. These are the unique feature which untouchable face. These are not untouchability is not faced by the scheduled caste, OBC. So you have to specify that separately, that how discrimination of OBC differ from that of scheduled caste, although there are similarity also. Now, same is the case with women. There is a similarity between the women and the scheduled caste, that both were denied right to property and right to education. Additionally, women were denied right to remarriage, and uh, they have to suffer widowhood, but they don't suffer from untouchability, which the scheduled caste suffer. Because of untouchability, their settlement are different, their social relation is less. Now, similarly, there is a difference between the discrimination of the discrimination based on caste and religion, or race and color. So they have to be mentioned separately, and caste has to be mentioned separately. So the argument of this general student is not sustainable, is not valid. And the other point is that there will be a reverse discrimination. See, in the Act, there is a provision: whosoever discriminate, high caste or scheduled caste or OBC, will be subject to punishment after the inquiry. So if the scheduled caste, scheduled tribe student discriminate against the woman, discriminate against the physically handicapped, or some sort of misbehavior with the high caste, there will be a provision of discrimination against them. It is only the Untouchability and Atrocity Act. See, the Untouchability and Atrocity Act, there is a very specific provision. The discriminator should be from the high caste, and discriminated should be from the scheduled caste. That provision is not this in regulation. Here, everybody is considered, whosoever practice discrimination. So, what are the why there are chances of discrimination of the high caste? There are no chances of discrimination. Why should the scheduled caste, scheduled tribe also file the false cases? Scheduled caste students are so weak vis-a-vis the high caste; they don't dare to file the false cases, and those who inquire into these cases, they are also from high caste. So this argument is I think it is politically motivated. It is not academically based as such. So these are, I think, some of my opposite view about this. So I would suggest, with the suggestion that I have made, and some additional things, if there are some anomalies, the 2006 should be improved and brought in.
Mhm. Yes, sir. Very forceful arguments, because untouchability and caste-based discrimination based on untouchability is unique. It cannot be tagged with every other form of discrimination. It needs its own handling. And the victims are also from a particular group, and it cannot be generalized that anybody can be a victim of that. And I don't know why such a obvious fact gets lost on. But like you said, it might have a political color to it rather than an academic or a logical sense. At the same time, you also mentioned that about fake cases. Uh, we all know that people who go in the reserved category or from the SC/ST OBC background, they are always submissive. They are always trying to fit in, and in that state of mind, very few will actually even to come up with a real case. It takes a lot of courage. Forget about a fake case. So there also doesn't seem to be a lot of teeth in that argument that there will be fake cases and so on and so forth. So moving on, sir, given these dynamics and the journey so far, as you explained so nicely, if we compare that with the forms of discrimination and the way it is handled in United States, that's where we are. So we have some sense of it, some idea about it. Though there is no caste discrimination in the United States, officially recognized at least, I mean, I will not say there is no caste discrimination, but there is no official recognition to that part. And there is activism going on that front, but at least at this point in time, it is not one of the criterias, except for the city of Seattle. But there are other forms of discrimination which are prevalent here historically, and I would say the racial discrimination, color discrimination is one of the most prominent one. Then there would be the gender discrimination, and but if we take the point in case of racial discrimination and look at its evolution, how that discrimination came into existence and how the society through various processes and various interventions are at this point where there is a efficient mechanism of handling discrimination at workplace, at the education institutions, and in public spaces. So before I add more to it, would you like to add anything on this comparison or on this side by side analysis?
No, I think there are 2 points I'd like to make. One is that there is a general provision of there is a general Civil Right Act in USA against the racial discrimination, and that obviously cover the education institution also. Uh, I think you see similar to that of Untouchability Offence Act and Atrocity Act. Atrocity Act is against untouchability and caste discrimination, but it also includes education, but very limited admission in education institution, but nothing much. Therefore, we had to bring this regulation specifically to the education institutions because lot many discrimination forms were observed. So I think that there is a legal provision against discrimination in educational institution, um, against race and other forms of discrimination. I think if you know a little more detail about it, you can add to that. But the
Sure.
most important point which I have been writing about the U.S. Education institution is, and I have written it in one of the article which will come in the Outlook after 2-3 days, is this: that the strategy used recommended in the 2026 regulation is twofold, as I say. One is that whenever discrimination is practiced, there is a protection and safeguard through the law, and though who he so face discrimination can make a complaint and committee will decide and deal with it. Second is the sensitization of the student, because the student comes with a prejudice and their own values and thinking on the campuses, and that reflect in their behavior towards the other section, Hindus vis-a-vis Christian or Islam or Sikhs, the high caste towards the low caste, male vis-a-vis the female. So all those, the diversity, whenever there is a diversity, there is a tendency of exclusion and separatism on the educational campuses. Now, in USA, if you go back to the history, The education institution initially were white male, and then it was followed by white female, then black male, then black female, then Latino, then the student from South Asian countries. So, and of course the girls. So you find that over a period of time, American higher education institutions, student composition was very diversified, as against the in the beginning only the male, white male. But when they discovered that when it is diversified, diversity has also resulted into certain problems. Uh, the student of different identities, when they enter into the higher education institution, they form peer group and relationship based on their social identity. So you have white and black peer group, or you have the Muslim peer group and Hindu peer group and Jews peer group. So that diversity automatically bring the separation and division, and in the process exclusion also. Now, the Ministry of Education, the Education Ministry in USA, recognized this, and it asked the Association of American University, Association of Colleges and the Universities in USA, to deal with this issue. So a committee was set up in 2000, and the committee studied this, and they came with one important suggestion. They say indeed there is a diversity results into the exclusion and division, and so they say that beside law, of course law is there, but there has to be certain effort to make the student aware about discrimination and develop the values in them, which will treat everybody equally. They enjoy certain right, they allow the other to have the same right, and the tolerance and understanding of other religious student. So they recommended a course entitled as a civic learning and democratic engagement, and that course was initially made compulsory in some of the university, but it is voluntary in some universities. So
Thorat sir, have a glass of water. We can pause.
yeah. So this course then contained, the discussion about poverty, inequality, racism, uh, discrimination associated with gender, elitism, classism, then the religious identities, the xenophobia, and then the prejudice against Christians or prejudice against Muslim and others. So that course content is very interesting. If you go to the university, you will find that. And students are required to take this course. So students take this course. As a result, what happened? There is an improvement in the perspective of the student. They understand these divisions are not good. They are not based on the basic principle of equality, liberty, fraternity, harmonious relations. And they also then, as a part of this course, the students are required to go visit the localities of the minorities, say black localities, and write a small project. See the life actually. That is what it's called democratic engagement. They also have a different, introduce a unique pedagogy, that is method of teaching. There is a group discussion, and everybody will talk about this religion and others, so that you develop a tolerance for the differences, and get to realize that those differences are not bad. They are there, but they are not counterproductive, or they don't take your right. So this course is a very proper instrument of sensitizing students, changing their old values, which they carry on the campus. Uh, it was mentioned in the report that what is required is the unlearning of the old values with which they come, and giving them the new values. And Milind, what happened? This was practiced in many of the university. Initiative was taken by Michigan University, study and all that. Then in 2011, after 11 years, there was a review of this, and the report came. It is called Crucible Movement, the report. And they discovered that this course has they interviewed the student, which had done this course. They found that, these students were of a different type. Their persuasion was different. And this is not only this, but their academic performance was also better. So they emphasize this crucial moment report is wonderful report. Now, in the 2026 regulation, Indian regulation, the methods of sensitization that they have suggested include that a student, when enter into the education institution, you take undertaking from him or her that he will not practice discrimination. Second, on the opening of the university or the colleges, the head of the institution will give a lecture in hostel and elsewhere. There will be a workshop, there will be a posterization. Now you can see that this is an indirect way of telling the student that what is better, but they are not really taught properly.
Mhm.
There is no course. They are not
Mhm.
educated through a formal teaching.
Right.
So I think this is an lesson from US which I have written, and I was the chairman of the Karnataka Education Commission. I submitted a report. I recommended a course in a different way. I recommended a course on constitutional moral value education. That the Indian student also, Indian campuses also are very highly diversified now. Scheduled caste, scheduled tribe, OBC, high caste, Muslim, Sikhs, Christian, male, female, high diversity. And the student comes on the campus with their own values and norms and prejudices. Now their perspective about others are they are taught in the family. So their socialization occurs in the family and in the society. Sometimes caste-based organization, religious organization. So they come with a prejudice. Hindu vis-a-vis the Christian and the Muslim vis-a-vis the Hindus, high caste vis-a-vis the low caste, the male vis-a-vis the female, rural versus urban, or English speaking and local language speaking. All kind of prejudices are there. Now you have this method I have told you that does something, but it doesn't really help. So what is important is there has to be a course which will teach them what are the problem of our society: caste discrimination, gender discrimination, religious discrimination, color discrimination, racial discrimination of students coming from Northeast India because of their food habit and other racially different. So this all discrimination, you have to tell them in the course that this is bad, this is a wrong idea. There should not be restriction, there should not be homogenization. That you eat this type of food, you discriminate the people, student who are vegetarian vis-a-vis non-vegetarian, or dress the Muslim girls which come with a hijab, they are humiliated. So this kind of attitude, that course should also deal with all these forms of discrimination and educate the student. And also they can go and visit Muslim locality, Dalit locality, and understand their problem. So I have suggested this course to the Karnataka government, and I think they will accept. Now, but this is directly from the US model. And this model is to be found in some of the countries also. I think in Georgia and Sweden. So this is the US experience. I thought I will share with you.
Professor Thorat, thank you so much. This is so illuminating. I mean, there is what you have described is a system that was facing the same problems that any community faces, where there is diversity and where there is animosity between groups or some lines of segregation. But then they found a solution, they implemented that, and we see the fruits of that labor. We see how the community, that society has shaped up in terms of handling diversity and inclusivity. We see that experience that in our day-to-day experience in the in US, in our workplaces, in our other public places that we go to. So if this same thing, like you have extracted the essence of it, and you have you are trying to promote those things in the Indian system, in the Karnataka Education Board, if that gets applied, that will be really a great thing. But I think that is where the solution really lies, where people
Yeah.
have to be sensitized in a meaningful way, not just as a good to have thing, but something as part of a course curriculum and so on and so forth. That really adds a lot of value to this interview with what you just mentioned about how something worked outside India and that can be applied to our own
Yeah.
system.
I would only like to add one more point quickly. Can I?
Sure. Take your time.
It is not that there has not been a realization of having a moral teaching in the higher education institution. Right from the Radhakrishna Commission report in 1948 till this new education policy 2020, they are all arguing for moral education of the student. In fact, the 2020 policy have developed a course called Mulya Prabha, uh, wherein they say that they will teach from moral value from various religion, from human rights literature, and also from the constitution for school and higher education. But in effect, what they have done is, if you look at the course content effectively, the majority of the values are drawn from Brahmanism. The Gita, the Vedas, the Upanishads, sometimes Manusmritis also. Although they are saying that we will draw it from Buddhism and Jainism, but they have not done that. Basically, it is drawn from the Brahmanical values, not even as much from the constitutions. So this is what has happened after the new education policy. So that is also a problem. So that's why I suggested that forget about religion. There is one important point that we must remember, that Radhakrishna Commission wanted to have a moral education course based on the moral values from the religion. Religion teach moral values. So Radhakrishna Commission has set up the committee, and they studied the religion to develop a course what is called moral values, what is called natural morality. The committee member came and they share with Radhakrishna that we can't do it. And he said, why? He said there are contradictory values between the religion. If you take Buddhism, it talk of equality, liberty, fraternity. The social organization of Brahmanism, caste system talk about inequality, restriction, antisocial attitude. He said we cannot do that. So it was then dropped and not done. But then this issue of teaching of religion and moral value was discussed in the Constitution Assembly, and Dr. Babasaheb Ambedkar has given a clear approach. There is a provision of Article 28. That interpreting that provision of Article 28, he said that distinction has to be drawn between teaching of one particular religion and study of religion. The study of religion we should allow. There can be Department of Philosophy, there can be Department of Comparative Religion, you can offer a degree, no problem. But you cannot teach the philosophy of one particular religion to the student. So as a result, that was accepted, and this religion-based education teaching was not considered. But now it has it has been revived, although it goes against the provision of the Constitution as such. So this is one thing, this point I wanted to share with you.
No, thank you. That's a great nuance. So, in the US, that journey that they had till 1960, till the Civil Rights Act, the blacks were segregated. The African Americans were segregated. So they have had a very, very strong discriminatory journey in the very near past. Our discriminatory journey goes back to like thousands of years. And from that point onwards, they have marched, the whole American society, I would say, to a much better place today, simply because there was will of the entire society to take those values and adopt them. So I think somewhere that will is of much essence. Laws will be there, regulations will be there, enforcement will be there. But till the majoritarian folks do not have the will to make that change, there will always be resistance. And like we are seeing in this case, even if the 2026 UCG regulations are a watered down version of 2012, but still there is opposition to it simply because of whatever political reasons or other reasons. So I think we should take, we meaning the policymakers and administrators should take some lessons from the American journey of how discrimination was handled and effectively its results are today. Today, when we go to workplaces, sir, we have to every year annually go through a disclosure of I will not discriminate on so and so basis, and we have to sign that. So in case any discrimination happens, then it goes against what we have committed to. So it is taken seriously to that level.
Yeah, yeah.
I think I had a lot more on the American side, but you covered it also well. So I think we'll leave it at that for now. With that, Professor Thorat, I think we'll conclude. We really want to profoundly thank you for this interview. It was very, very illuminating. It was enlightening. And as always, we are fortunate enough to have your guidance. And on this new YouTube channel that we have, it's a pleasure and privilege to have you in this program. Thank you so much. And we hope that this journey of this particular bill 2026 happens favorably, and reason sees its way through it, and things work out better. Thank you so much again.
Thank you very much. And I appreciate the initiative taken by Ambedkar International Foundation by starting a YouTube channel. Yeah.
Thank you.
Thank you. Yeah. So shall I close down?